Siddhant, shall we start? Hello. Uh, s- yes, Yash.
Shall we begin?
Yes,
Okay.
yes.
Good evening, everyone. I am Yash, an associate at the EduLaw. Welcome to all of you in today's webinar session on basic concept of contract drafting. In few words, I will discuss about the EduLaw. In legal education, we close the gap between theory and practice. We bring business knowledge into the world of legal practice. We bring knowledge into the world of legal education, making it simpler, quicker, and more affordable to master the practical skills you will need to interact with clients more effectively, swiftly, and economically. We are constantly updating our legal dictionary, legal magazines, legal databases, and much more. You can check our website link, which has been posted in comment section below. Today, we represent Advocate Krithika ma'am, a renowned corporate lawyer based in Bangalore. She was also academic head of the Indian Institute of Industrial and Professional Institute. Her specialization is in contract drafting and negotiations law. She was also a legal advisor at Roy Technology University. Thank you.
Okay, so shall I take over the session?
Yeah, sure, ma'am.
Okay, so thank you everyone for this introduction of mine. I'm really honored to be here at EduLaw. So yes, without any further delay, I think we can start with the session. I don't think I need to introduce myself because yes, he has introduced me very well. So I think we are good to start with the session. So the first, okay, one second. Okay. So here in this session, I'm going to speak about the basic of contract drafting. So what do you mean by contract drafting and what it is all about and what is a basic thing that we should be studying? The first thing, let me clear you uh, that whatever you have studied in the college is nothing in front of the practical knowledge. Okay, it is a totally different phenomena, and it's like it's not even that introduction that you have studied for contract drafting. It is just, I could say that it is an overview of something. It's like, for example, now if we see Himalaya mountains from here, we will feel that, oh my God, how beautiful it is. It is so tiny and all other things. But when we start going nearby, we will understand it's how huge it is. The same thing is with contract drafting. Even I am not an exception to it. Even when I was a student, I was like, what is this contract? Is all these things, etc., etc. But
Stop
when
mute कर मेरा.
is that to me?
सब तो
I
mute
think
कर मेरा.
I can hear my own voice. Okay, now it's not there. Okay. So the thing is, like, even I felt like what it is, how, what is a career in contract and all other things. That was something which I was not able to understand it. And also I was like, what's there in the contract? It is, you have to understand what is time and place, what is that, what is this, that's all, and you have to write few lines. But writing few lines is very very difficult. That I understood after coming into the profession. So now let me tell you what is contract and what it is academically and what it is professionally. So the first thing is, all of us, we know, if you are a law student, you will tell that when I ask what is a contract, you will tell that it is an agreement that is enforceable by law. As a law student, we only know that much. But professionally, it is not only limited to an agreement enforceable by law. Every sentence, every word over there has a in-depth meaning. So, what is an agreement? What paper is considered as an agreement? What is a legally valid agreement? What is a void thing? And then enforceability. Who is going to decide whether it is enforceable or not? What is a criteria for deciding it is enforceable by law, enforceable or not? Next, law. What is law? Which law is applicable? Is it only Indian Contract Act? No, it is not just Indian Contract Act, but it is many other laws that are combined with that of the contract drafting. I'll give you an example for this. Now, suppose if you are drafting an license agreement for a hotel franchisee, okay, so they are giving the license. So over there, it's not just Indian Contract Act that you are going to refer. You are going to refer the FSSA Act, the Municipalities Act, the state laws, the land laws. You have to refer everything over there. Same way, if you want to draft a technology transfer agreement, it's again not just Indian Contract Act. It is IPR. It is all the related IPRs, whether there is a patent, trademark, and in addition to that, you have to know, are there any other regulations that are governing it? For example, if it is a software, then we have so many guidelines for software. If it involves market data or data, we have so many regulations which speaks about data privacy, data regulation. So we have to be knowing that too. And the next one is if it is involves any sale and purchase, if there is any consideration or if there is any taxation, but you should be knowing even that. So it is not just Indian Contract Act. It is many other legislations that are applicable to them. So it is not just the definition. It is so much broad when you apply it in the practical world. Now, contract professionally, it is the bread and butter for all the advocates and even for non-advocates people also. Trust me when I say this. You can ask any person. I think I can give you an open challenge regarding this. It is like any person you ask, they will tell that they have dealt with contracts, and they will tell you that yes, contracts are important, yes, contracts are, because the contract disputes are leading to litigation, and that's why we are earning money, and contract drafting. So it's contract wherein I even mean the sale deed, the transfer deed. Real estate is totally dependent on contracts. Okay, all the deeds, even they are called as contracts. So all the practicing advocates also, they will be referring to the sale deed, they will be referring to the mother deed. So it's one or the other, they are into contracts. And second part is procurement, sales, businessmen. These people also, they require contracts because they will enter into business transactions, they will purchase goods, they will sell goods, they will avail services, they will provide services. So whatever it is, what is the terms that you are going to agree to provide the services, that is the contract. Okay, so the contract is technically, I mean, very much practically, it is the bread and butter for most of the profession. And also the job sector, because many students, they ask me this question, how pandemic proof is job in contract world, contract domain, or how can I mold myself in the contract career, and is it good to have a contract related career to jump into CLM or something like that? I tell them, see, whatever business you do, it require contracts. So now if you see my profile too, I have worked in with an industrial advocate, I have worked in a state private university as a legal advisor, I have worked with an consultancy firm as the senior counsel, and now even here at my current company, I'm working as a senior analyst. So my companies have been all different portfolios, but one or the other way, they wanted the contract person to deal with it. Okay, so if you can ask me, why does a college require a contract specialist? Yes, they do require. As a university, they'll be entering so many MOUs with the concerned authorities, so many with the government authorities, so many with the international universities, and so many with the banks. There will be so many transactions, and all of these will have contract people as their legal counsel who will look into all of these things. So once you are expert in the contract, or once you decide that yes, I want to make my career specialization in contract, then trust me when I say this, that this is one of the wise decisions that you have to make, but one of the hard decisions too. Now, what is the significance of contract? Okay, now I said every business requires contract. Why does every business require contract? That is because this particular document has everything that is related to particular business. This black and white document has the future of the business embedded in it. So it is all about the what I could say, the activities, what is going to take place in the future. Like we have our horoscope, right, which in which they will mention about the sunshine, the sun star, and they will look into it, astrologers will look into it, and they will tell, oh, he has this yoga, he has that yoga. The same way contract is also something. They will not tell you yoga, they will tell you the liability, they will tell you your benefits, they will tell about the clauses. The contract manager will tell all these things looking into that piece of paper. So it has the future of the business in it. And also, now we have seen that whatever law that the country enforces, it has to be in consonance with that of the Constitution of India. Okay, that when I say this, we have seen many sections. You can tell example of Information Technology Act. So many sections were overruled, were cancelled by the Honorable Supreme Court, stating that it is not a valid thing and it is unconstitutional. So, what do you mean by the term unconstitutional? That is, which is something against the contract. Okay, so something which is against the constitution. The same way, if something is against the contract, that will not be held liable. Okay, so that is something wherein I could say that it will be held as not a consonance with the law, or it is not valid, or it is something which is to be quashed, something like that. Okay, so the significance that constitution carries to our country, the same significance contract carries to a business. So I hope now you are very much clear why the contracts are very, very, very important for a business. And also, if you ask a practical person like who is into business and who is into contract management, even if you ask me, I will not define contract as an agreement enforceable by law. It is way too old for me now. I would tell that it is a piece of paper which defines what can be done, and if it can be done, how it has to be done, when it has to be done, where it has to be done, and also how it can't be done. And also it will answer the questions like what to do when it is not done, when to do it when it is not done, and what is the liability, what is the term that I have to take to take necessary actions, what are the exceptions that are being given for not doing that particular thing. So all of these questions will be answered in the contract. Okay, so it will answer all the questions arising out of that business transaction, and only then it will become a good contract. So how to draft a good contract? Before that, you have to do the contract negotiation. So what is contract negotiation? This is nowhere in the Contracts Act. You will not study contract negotiation as an academic syllabus or academic part of yours. You'll just have an introduction, I believe, that contract negotiation is something that exists. So professionally, contract negotiation is a process wherein both the parties, or if there are more parties, all of the parties, they sit, they discuss, and they come at a common conclusion, which is mutually acceptable and beneficial for all the parties. So this is the professional definition of the term contract negotiation. But practically, it is presenting the term that is beneficial to your client as the ones that are beneficial to the other party. Okay, see, if I have to tell something, then I have to give something to other party also. Okay, so there should be, it is not necessary always in the monetary terms, it can be in the other part too. Now if I'm telling them that, okay, you procure business only from me, why should I be the only person? I should give them some reasons for it. Unless and until I convince them, I will not be able to get that benefit. So you should be able to color code your benefit as the benefit to the other party. Okay, you have to present that yes, this is benefit. This is my thing to my thing to you. More than me, you are going to get benefited. The best example for this is I can tell you our parents. Our parents will come and tell us, study hard. We are telling for your own good. If you don't study, what for me? It is for you. All of these things. There, they are doing a negotiation with you. They are quoting their benefits like it is beneficial to us. See, even they want us to study well. Even they want us to score good marks so that we'll lift up their collar and they'll like, see, my son has got, my daughter got highest in the highest grades, and they want to move like that. And also they want their child to reach good positions, earn good money, be happy in life, be satisfied, all of those things. But they want it, but they will figure it out, or they will picturize it that it is for your good, it is not for my good. Okay, so this way they are showing you that yes, more than me, you are going to be benefited. The same thing happens in the contract negotiation too. You will present your terminologies or your client's benefit as that is benefit to the other party. Now, why should we do this contract negotiation? Now, you have drafted a contract. Suppose you have drafted a confidentiality clause. So now when you have drafted a confidentiality clause, you have put up the definition of confidentiality term, like whatever said verbally is also a confidential information. Now that persons, they are not ready to accept it. They'll be like, no, we cannot agree for this. It is not something agreeable. So we are contradicting it. So that way, you that at that point of time you should tell them, no, this is not acceptable, we cannot do this, and this will be beneficial to you, your interest will be protected. Tomorrow we cannot come and ask you that we cannot come and ask you, give us that, give us this is information, that is information. So all of these things are not there. Okay, so you have to tell them that yes, that is beneficial to them. And also the second example I will give you is you are drafting an employment agreement. So when you draft that, you have put up this non-solicitation and non-compete clauses. Then they'll be like, oh, no, this has non-solicitation and non-compete clauses. This is very at that point of time, you have to tell them that you have to negotiate with them and you have to convince them that yes, they have to agree for this particular non-solicitation and non-compete clauses and adhere to the terms of the agreement that you have drafted. So now we studied the phases, and now what is contract drafting and how do we do the contract drafting? So here in the slide you can see the contract drafting, preludes and mandates. So what should be there in the particular contract? The first one is preamble. So preamble is the place wherein it introduces the parties. It defines the parties. It tells who are the parties, what are the legal entities, or are they individuals, what are their address, registered office, how to track them. All of these things will be there in the preamble. And recitals to the contract are where it tells what is the background of the contract, what is the brief thing, like if there was any RFP, RFI. RFP is request for proposal, RFI is request for information, or if there was any tenders or there was any other kind of proposals made. So it will tell about the background. After that, you will write about the purpose or the objective, like what is the main objective, why are you entering into the contract. After that, you will tell legality of the parties. See, this is very important. You have to mention how are they authorized to do this particular act. Now, for example, now when you are I'll give the same example. If you are doing an license agreement for a hotel industry, then you should be mentioning that are they authorized to do it, what is the FSSAI license number, and what is the permission that they have taken from the concerned authority. So you have to specifically mention their legality part. Now also, one more example is if you are entering into any research agreement or something like that, then you have to tell them that okay, what is the research that they are doing and how are they doing, what are they doing, how are they authorized to do it, do they have any approvals, or if you are doing any construction related agreements, whether the constructor is having any legality, whether he is a registered civil engineer, what he is, what not he is. So that has to be mentioned. After that, the applicable laws. What are the laws applicable for that specific industry? That has to be mentioned. And then the terms and conditions of business. How are they going to do the business? What is the consideration that they are going to pay? And when you mention about the consideration, it is very important that you write about the taxation part. Many a times people miss out writing the taxation part, and this leads in their dispute. They'll be like, no, this is inclusive of taxes, this is exclusive of taxes, and nowadays taxes rate also very high, and therefore it is very important to write the taxation part along with the other monetary terms in the contract. Next one is boilerplate clauses. Boilerplate clauses are the clauses which are to be present in the contract. For example, your severability clause, governing law, and governing indemnity, liability, termination of liability, all limitation of liability. All of these things, all of these clauses are called as boilerplate clauses, followed by the signature. At the signature part, if it is an if it is a legal person, that is if it is a company, partnership firm or something like that, then the common seal is mandatory. So you should have the seal affixed in the signature part. You cannot miss the seal. Okay, unless and until it is electronically signed, then you can skip the seal part, provided you receive it from their authorized email ID that this is the signed one, or you have requested via DocSign or any other tool. Then that's fine, well and good. But still, if it is the offline paper, then seal is something which is very mandatory. So this is all about the drafting of contracts. Now I would like to give some tips related to the contract drafting. The first one is language and simplicity. Yes, this is very, 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 very important that you have a simple language in your contract. This I have personally learned in my work experience. I can share you a few instances wherein what happens is I had used words like the force measure, and they're like, okay, what is this force measure? This sounds something which is very Latin and French to us. We're not able to understand what are you writing and all other things. Then I understood, okay, force measure is something which is very common to me as a legal person, but the other people will not be aware of the words like force measure. Then okay, I thought, let me make it little simplify them and let me write it. But over there I could not find a substitute for that particular word. But then I understood that okay, let me explain this to them, let me put whatever the definition that I put in, I'll use that particular words in it. And also when you are using this particular things like for example, software transfer agreement. So in the software transfer agreement there will be so much of softwares. Now we have studied LLB, what do we know about these softwares? Okay, but still you should be knowing it. You have to understand little terminologies related to it, and if there are any difficult terminology what the business people have given to you, ask them for the meaning of that and add it in the contract so that it is for the easy reference. Because the people who are signing it and who will later interpret it will not be from the software background, they will be from the business background, like the management, and not necessarily that they should be having knowledge of software, though they work in the software industry. So therefore it is important to use the proper language in the contract. And also I have seen a circumstance wherein there was a contract dispute which landed in the court, and this was only because this was an arbitration. This was only because there was mistake in the singular and plural thing. Okay, wherein he had mentioned it in the singular thing. Okay, for these terms or something like that. So the other party said, see, this is a singular word. That means it is related and it is confined only to this. This is not plural. So if it was plural, it would have been applicable. So this is not applicable. Unfortunately, the other person could not prove that yes, this was a typographical error, because even in other places also he had mentioned it in the singular form only. So they said that, see, one place we can understand that yes, there was a typographical error, so that yes, apostrophe yes got missed, but not in all the other places. Okay, so then it was held that yes, it was agreed for that one particular product, and yeah, it was product, not for the other products as well. Okay, so that led that one small apostrophe yes costed him to lose his case, though he was very much genuine, though the contract, everything was done in his favor, everything was there, all the proofs, all the documents, but still he couldn't win in the arbitration only because of that particular apostrophe yes. And also the court had to agree that in one place you can tell that it is a typographical error, and other places you cannot. And also it is understood that when you have signed a contract, you have read each and every line of it. Okay, and the next one, and also one more example I would like to give here is, we all of us we had that app which was changing our face, like we used to look either young or we used to look old and all other things. That app was there, and that app's terms and conditions, we never read it, we just look into it and we just accept it, finish, done and dusted. And then it was read by somebody, and that person highlighted that this terms and condition has a clause that the app can use, can access your gallery at any point of time, not just the image that you have clicked, but even other images too. Okay, and also I'll give you one more example of the same kind of the terms and conditions. That one, which my friend had encountered, wherein he had he had taken loan from an app. Okay, so they said that okay, 2 lakh we will give, all other things and all. He took a loan of 2 lakh rupees, and there was terms and conditions, and he clicked on that, and all of that was like okay. After some time, he did not pay that amount. So he was facing some financial crisis. He was not paying the amount. Then that people loan the app concerned authorities. They started calling to all of his contacts. And one fine day, they did with one or two other contacts, and they're like, "Hey, you know, your friend has taken loan from us. We tried calling him, but he was not reachable. Can you please put him a word that we had called, and he has to repay our loan?" And then one fine day, that had happened multiple times, and he ignored my friend's friend. He ignored, and one fine day, what happened is that app people, they sent message to all his contact people, telling that he is in a very big financial crisis and he needs money, he needs that, he needs this. Please tell him to pay our money. All of these shit things. And then he contacted the app, and he's like, see, how can you do this? He's like, haven't you read our terms and conditions? It is there in our terms and conditions that we have access to your contacts. And now what we can do with your contacts is up to us. This is our mode of recovery. So you should have seen before you accepting the terms and conditions. If you have any problem, please go to the court and challenge this. And then he contacted my friend, who in turn contacted me. And then I said him, see, they cannot harass you this way by sending emails to everybody, by asking everyone, do that, do this, and all other things. So this is not a part of the terms and conditions. And wherein even I had to read that full page, like it was around 25 to 30 pages terms and conditions. And they had clearly mentioned that once they log in and once they register to the app, that particular app will be synced to the Gmail account. And from there, whatever the contacts you have taken and whatever the email ID you are having conversation with will be transferred to their database. They'll have a copy of that thing. So whenever you download any apps or something like that, be very cautious, be very mindful. What is the app that you are downloading? Try to read their data privacy policy or the transactions policy, so that you don't fall to such scams and end up losing your dignity in front of so many other people. Like he was telling me that he had his college principal's phone number also, and the principal called him to the chamber, and he's like, oh man, you took loan, and that principal thought that he has given his number as the guarantee person. And he's like, oh, you made me guarantee without any confirmation of mine and all of these things. You better pay money or else I'll take action against you. I'll debar you, all of these things. And he was like, I had a very tough time convincing my college principal that I did not take any mark you as guarantor at any place. It was not at all like that. I just had my number saved, and this is a scam that had happened to me. So all these things happen. So see, now whatever they're like, yes, we had told them that we will take our this thing. We had a data sharing agreement. He had agreed to share his data. It's not our fault. See, they cannot take our data without our consent. When we click that button that I hereby agree to all the terms and conditions, we agree to give them our data. Okay, so this is something which is very important to keep in mind, and very important to understand that you should not be clicking any and every terms and conditions wherever you see it. Being a person from law background, or being someone who is in the law fraternity, you should be well aware of these terms and conditions, and also these scams that are happening in and around. Now, coming back to drafting of contract, yeah, simplicity matters a lot. Keep it as simple as possible. Do not use all your Latin maxims and other things in the contract, that as per this Latin maxim and all other things. Do not put those things. Keep it as simple as possible. And next one is imagination. You have to imagine, आगे क्या होगा? Will that happen? Will this happen? Will there be any fight? If there be any fight, why will the fight be? What to do to resolve the fight? You have to imagine, you have to think, and then you have to put the solutions for all those imaginary problems. Okay, so I tell that in once a person had asked me, why do you think that you are good in the contract drafting? What makes you feel that? I tell them I have this psychological habit of having anxiety, panic, and overthinking, and I think that is helping me to excel in my profession, because I overthink a lot. I overthink a lot. If I see a pen, paper, and whatever other things, I'll start thinking, okay, what it is, and it is like so many things happening in and around. And I think that is somewhere required to be a good contract drafting. So if you're also overthinker, then 50% of your job is done in contract drafting, because you will know all the possible situations, you will be knowing all the possible solutions too. And next, blueprint. So blueprint is very important for a contract draft. See, even though we are even before building Burj Khalifa, they did a blueprint. So what is a contract, right? So you have to do that one also. See, even for drafting the constitution, they had a blueprint. Whatever it is, they will have a blueprint. We in our classes also, we have timetable. Okay, kitne baje the class hoga. The same way, even with a contract, you should have a blueprint. You should be knowing what does your client wants from this specific contract, what is your client's need from this specific contract, and based on that, you have to draft the contract. Next one is common sense. Yes, common sense is an essential ingredient to be successful in life. It is not just your dedication, it is not just your honesty, it is not just any other factor, but also common sense is very important. I think it is the most underrated skill, I could say, because common sense is not found in everyone. It is a kind of blessing, I would say, Okay, so you should have good amount of common sense, good amount of understanding when you are speaking to someone, when you are negotiating any contract clauses, or when you are proposing something. You should have that common sense, and you should understand what are you speaking and how are you speaking. Okay, so you should not utter things, and also common sense, wherein I mean that you have to be sane at all the point of time. Like, you should not lose your calmness when you are telling one thing and that person is insisting, no, 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 no. That person also will do so much of bargain, but still you have to have your calm, and you are like, okay boss, see, this is the thing. And you should be having a same tone throughout these things, and you should be knowing how to tackle the other person with the help of their body language moments. Are they interested in listening to you, and how are they confused? Do they need some time? So you have to do that. So that will be possible only in the common sense. And also, if you are into freelancing, even there you should have common sense to understand what is your client's expectation from you. What does the client wants? The same thing, I'll one example I'll give you now. See, today you will be hungry. You're like, I want something to eat, and I want something to munch and something like that. And you tell your mom, please cook me something good, something nice. And when you tell that, you expect your mom to cook some dish which is of your favorite, like pav bhaji or something like that. So instead of that, your mom comes with a boring dish, that you which you find it not much interesting or appealing, like poha or upma, something like that, which you eat on a regular basis. You're like, I did not expect this on a Saturday evening, and I wanted some snack to eat. You're giving me this. That happens. Though however good she has cooked it, you will not find it appealing, and you will not find it nice. That's because that wasn't your expectation. So it is your mom's common sense to understand, okay, my son or my daughter wants to eat something appealing, not the regular food that they eat, so they have to cook accordingly. Okay, the same way you have to understand what is your client's requirement from this particular contract, and on that basis you have to draft the contract. Next one is knowledge of applicability of law. Yes, see, knowledge of law is different. Knowledge of applicability of law is different. So all of us know that we have this provision of defamation under section 499 and 500 of IPC. But do we know how to apply the provisions, how to bring in actions? Should we do an FIR first, or should we file a private complaint first? What should we do? How should be done? All other things. Okay, so that is very important. So you should be knowing the applicability, as well as you should be having the knowledge of the law, how to apply it, and what is that particular knowledge. Next one is I to detail. Yes, I to detail is very, 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 very important. You should be reading every single line. You cannot skip anything in the contract. Even though it is a footnote, even though it is a page number, you have to look in detail to it. You cannot skip anything. It's like an eagle's eye. You should be having the thorough information, and you should be having every detail known, including the footnotes. That is very, 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 very crucial. So yes, this is the few of the tips that I had to give you while preparing to the contract drafting. Now, I would like to know if there are questions related to any of the topics that I have discussed. Yeah, I think I have got few questions. Let me go to the first question. Okay, so the first question is, if I was mistaken about some of the contract terms when I entered into contract, can I get out of it? That will depend on the termination clause. What does the termination clause of the contract says? Okay, so over there you can terminate that particular contract. And also remember, ignorance of law is never an excuse. If you have signed something, it is understood that it is predetermined that yes, you have read everything and you have understood everything. Okay, so it is very important to read every line and then sign it. In case if you have done like that, then you can refer the termination clause and terminate the contract, or you can do the amendment to the contract and you can change that particular term, or you can do addendums, that is you add additional terms and conditions to the contract, or you can even novate the contract. Novation of the contract is wherein you are replacing the exact contract. Okay, so the next one is, what if I don't understand the legal terms used in a contract? In that circumstances, you have to refer to your legal counsel. You have to get it reviewed by an advocate. That is very important. Even see, I'm not just selling as an advocate or a business person who is advertising it, but even otherwise, you should be asking an the particular person, the legal counsel, that what is the legal terms, what are the consequences of this, what is that, what is this, what are the terms that are mentioned in the contract. So you have to ask them and then you have to enter into the particular contract. And yeah, the next question is, uh, uh, does the contract refer to any other documents I don't have in my possession? Yes, the contract can refer to the other documents that you don't have in your possession. For example, I can tell you SOW. Statement of work is something which is under your MSA. So you may not have the possession of MSA, though you have signed, or somebody before you have signed it. So it may have reference to that. Or a sale deed. So when you are entering into something, it may have reference to the mother deed, a parent document. You may not have that in your possession, or you may not have that in your possession. To get copy of all the documents of which the signing document or the current contract has reference to. And also, if it has any links, then it is always advised to take the format of that particular link and attach it to the contract document, because website is something which is in the control of the third party. They can modify it anytime you. So it is very important that if it has any terms and conditions, it has to be recorded. Okay. And what are the remedies available to me if the contract is breached? Yes, you can appeal the conditions of your contract. If it has anything related to the court, so it will depend on the terms and conditions. Okay.